I'm one of the owners and founders of Mountain West Financial, and I'm joined today by Ann Savage.
Hello, everyone. My name is Ann Savage. I'm the Vice President of Legal and Compliance at Mountain West Financial.
We appreciate you spending a short time with us today and over the next several weeks as we visit the upcoming compliance laws, rules, and regulations and how the different lenders, and especially Mountain West Financial, will be implementing them. We realize that although it's critical that you get this information, we also understand that there's a lot of different demands on your time, and we want to make sure that we make this valuable use for you and that we give you information in sound bites that are concise and in English so that you can not only understand them, that you'll have source documents to go back to, and also that you'll be able to implement them with a common sense approach. We're going to spend approximately 30 minutes every Monday as we record these, where we'll go through different aspects of the compliance and regulations as they come up. We're going to start with really general overviews to give you an idea of where they came from, how they were created, the different regulators that are out there, specifically the CFPB for most of them. But then we're going to take a deeper dive into some of those that are more critical to our day-to-day activities. And ultimately, towards the end of our compliance webinars, we're going to get more into a granular procedural, step-by-step of how to make sure that we're all compliant going forward. If you're not able to attend one of the webinars, don't feel bad. Well, you should feel bad, but don't. Because we will record each one of them. We will put them out every Monday at 1:30 where we'll do them live, but other than that, we'll record them so you could visit them during the week. Just know that we will be building on them week after week after week while we build the entire, again, start with a real basic platform and understanding how we got here, the importance, who's doing what. Then we're going to get deeper into, again, the critical ones, and ultimately towards the end, we will give you more how to make them work. I need to do a little disclaimer here, or actually I'm not, but our VP of Legal and Compliance will.
Well, first of all, this is not intended as legal advice. We are not your employer, broker, or legal counsel. This webinar series is intended to inform you, enlighten you, and help you be able to do business as easily as possible with Mountain West Financial, as we particularly at the end of the course when we get into the actual implementation of the regs and our change in process.
Good. And we should say, or at least I should say, that we don't, or I don't necessarily agree with all the regulations that are being put on an already strained industry. But being non-compliant with them is absolutely not acceptable way of doing business, not only for us, but for you as well. And I want to make sure that you do realize that being non-compliant with the regulations as they are put forward will create fines, penalties, license suspensions, and a whole bunch more. And Ann will get more in depth in that as we go along. So not to mention a reputational risk, not only from the investment community, the lender community, but also with your business partners out there. So we're very pleased that you're going to allow us to share our thoughts and insight and the information as we have received it over the next several weeks. And again, we'll be exploring not only the compliance piece, but we'll be looking for opportunities as we have in-depth discussions. And ultimately our goal is that you'll be better able to serve your clients, you'll make sure that you are compliant, and hopefully we'll all remain profitable. So with that, we're going to get into today's presentation. So I want to remind you that these are considered Compliance Mondays, but you may be listening at this during a different time during the week. Today we're going to start off with the foundation. And again, it's going to be Ann and Gary that will be providing this to you week after week. So for the next I want to go and do a brief history of how we got here. And I'm going to make this very brief. First of all, there was pressure from politicians for home ownership. This goes back in the 2003 and 4 era. Regulations became reduced. Buckets for credit qualifications became much larger. And ultimately, all of us know there was a mortgage meltdown, right? This got into 2006 and the 7s. Those same politicians that were pressuring for home ownership all of a sudden became the let's safeguard the homeowners from the lending industry. So they came out and saved the day. There was a regulatory onslaught. So here we are today. Just remember that a lot of the regulations that we are implementing now and that have been implemented over the last several months or year really started their genesis back in the 2007 and 8 year. It just takes that long to get this out. And know that the pendulum has pretty much moved all the way from one direction when we were going into 2005 and there was almost no rules to where we're almost burdened with being able to get a loan through from one side to the other. But that's history. We all know how that works. So let's fast forward today and let's talk about the effects of the Dodd-Frank Reform Mortgage. So first of all, Dodd-Frank Wall Street Reform and Consumer Protection Act. We know what it's called. There's actually over 1,300 pages between the original act, the rules, regulations, and official commentary. It called for the creation of this new agency, the Consumer Financial Protection Bureau. From here on out, we're just going to refer to it as the CFPB. And it amends many current regulations, and ones that really are near and dear to us in the lending industry are TILA and RESPA. But just know that we're not the only industry that they're effectively working and regulating and have oversight over. But it's combined many current regulators into one very powerful. And there's some that would argue that the CFPB could be the most powerful government agency out there today. They have very little oversight. And, you know, as our government, most of you that have had social science through the years, you know that there's checks and balances. And, again, depending on who you want to listen to, these guys may not have as many checks as some of the other arms of the government. But that being aside, it will have effects on almost all major transactions in the U.S. and more specifically to us, it touches almost every area of mortgage lending. So I'm just going to go through and discuss some of the authorities that have been transferred to it. And we're going to go through this pretty quick, and you will have a copy of this PowerPoint, so if there's any of this that really becomes endeared to you, you'll be able to get back at it. But there's a lot of, you know, from authorities transferred, it comes from the Board of Governors. There is Equal Credit Opportunity Act. We call that ECOA. Reg B, Home Mortgage Disclosure Act. Reg C, we also refer to that in the industry as HMDA. Electronic Fund Transfers. Registration of Residential Mortgage Loan Originators. SAFE Act, right? Those of us that have NMLS license numbers. Consumer Leasing. Privacy and Consumer Financial Information. Fair Credit Reporting. Truth in Lending. Truth in Savings. These are all transferred over to the CFPB. Also from the Department of Housing and Urban Development, or HUD, hearing processes pursuant to the Administrative Procedure Act, civil money penalties, certain prohibited conducts, land registration, purchasers, revocation rights, sales practices and standards, formal procedures, and rules of practice, Real Estate Settlement Procedures Act. Some of you guys may know that as RESPA. Investigations and Consumer Regulatory Programs, but only as applied to RESPA and ILNAs. From the Office of Thrift and Supervision, the OTS, this also went over to the CFPB. Things about adjustable rate mortgages, registration of residential mortgage loan originators, and again, remember that's the SAFE Act, those of us with NMLS licenses, privacy of consumer financial information, fair credit reporting. Now, the reason why I keep going over this is we want you to realize how many different government agencies and resources funneled into the CFPB, because that kind of sets the stage for why they're involved in so many aspects of the different lending we do. But they've also taken over telemarketing, sales rules, privacy and consumer financial disclosure requirements for depository institutions lacking FDIC insurance, mortgage insurance relief services, use of pre-notification negative option plans, cooling off periods for sales made in homes or at certain other locations, preservation of consumers' claims defenses, credit practices. We're going to go on, and as it continues, it talks about mail and telephone ordering of merchandise, disclosure requirements prohibiting concerning franchising, disclosure requirements prohibiting concerning business opportunities, again, fair credit reporting, procedures for state applications. I go on and on and on. So we've just touched on some of them. There's others that actually more affect some of the smaller banks and also affect larger banks as well as credit unions. So let's talk a little bit about the CFPB history, how they got here, and what's going to happen from now.
All right. I think it's interesting to start with the fact that in 2007, Professor Warren, Elizabeth Warren, proposed an all-encompassing consumer protection agency. She was a Harvard law professor, and she had an interest in this area, and so she proposed this agency way back in 2007. I don't think it had any traction to speak of until the 2008 financial collapse. So when that happened, of course, there was all the excitement and lawmaking and wringing of hands and politicians running to the rescue that Gary alluded to earlier, and the Dodd-Frank Act was passed in 2010. In 2011, Richard Cordray was nominated as the director. The interesting thing about that, in some ways, I'm not going to go into all the boring details of it, but there was very little authority granted to the CFPB until they had an acting director appointed. That's why there was all that litigation and argument about whether his appointment was appropriate, et cetera. At some point, that was obviously all settled, and in 2012, they had the authority to start issuing all their rules, and they went full speed ahead. They started out with a lot of procedural things that really, I think, is important to understand because it really impacts things you wouldn't consider. So one of the first rules that they put into place was they changed the way the regulations were published and would become legally effective. They used to have to go through a public comment period through the Federal Register, and then after you had the appropriate comment period, then they could issue the rule. Well, they changed that. Basically, they still have been publishing rules out for comment, but they don't do it through the Federal Register. They do it through their website. It really gives them a lot of flexibility.
As well as power.
As well as power. Basically, regulation by fiat. They also limited procedural rights in a lot of ways. One of them you may have heard of is they're changing the rules on attorney-client privilege, for example. They are changing the rules on the process for appealing any order. So if they order you to pay damages or cease and desist, you have very limited options to try to appeal that in very limited time frames.
And who would we appeal that to? Them?
Yes.
Perfect.
And you only have 10 days, so you have to be pretty quick. Yep. It depends on the particular circumstance, but in any event. Another thing that they did is they reissued all of the regulations that Gary went through just a moment ago. So all the citations that you've learned over the years, you might as well throw them out the window because they're all different now. They did attempt to preserve some of that. So, like, I think Reg Z is like, well, I won't bore you with the details. You can tell I'm a lawyer, right, Gary? I think one of the most important things, though, from a business practice point of view is the exam manual and the introduction of the compliance management system that is contained in that manual. Their intention is basically to have all lenders follow a traditionally banking-oriented compliance management system process.
And I do have to say the one thing that they have done that I think has been more transparent is they put that manual and most comments and their regulations in one place. So if you visit their website, those items and what they're requiring are in print.
And one place.
And one place. Whether they're entirely clear or not, again, can be argued. But at least they are putting it in one place. And to that point, all the different regulations that we discussed that are being put in there are at least in one location, under one umbrella and one supervisor.
Right. And that is useful, I would agree. 2013, the focus for the CFPB was really on the mortgage industry. So let's go to the next slide. In 2013, they issued their final rules for RESPA, TILA, and ACOA. They issued some of them a couple of times. The main issues, I think, that we'll be covering in subsequent webinars is going to be LO-comp, ability to repay, what's a qualified mortgage, when you have to have skin in the game, how how a loan is considered, how it's calculated to see whether it's a high-cost loan or a higher-price mortgage loan, escrow and appraisal changes, just a lot of different changes. The one thing we're still waiting on is the combined RESPA tail disclosure. And the CFPB has published a schedule, and they're indicating they are going to publish it in October. I don't think anyone expects it will be required to be implemented by January 1. Obviously, I mean, I think that's pretty obvious, but we think it will be issued in October. I want to go into a little bit of detail about the authority that the CFPB has. Well, one of the things that they were directed to do in the Dodd-Frank bill was to educate the public about financial decisions and products. They're also in charge of regulating the financial industry as a whole. That's why they were given authority over 19 different regulations. They have very broad enforcement powers. We'll talk about that in a little bit. They also feel it's their duty to manage consumer complaints and restrict unfair, deceptive, and abusive acts and practices. The CFPB has the authority to regulate a number of different individuals and entities. Basically, anyone that provides any sort of consumer financial product is under their purview. Any non-depository providing origination, brokerage, or servicing of consumer real estate loans is subject to the CFPB authority. Certain larger depository institutions, and then service providers to all of these entities. One interesting factoid, I guess if you'd like to put it that way, is that there is some shared responsibility still out there between the CFPB and the FTC. The FTC still has enforcement authority around the Federal Trade Commission Act against non-depositories, which is, of course, critical to us. While the FTC is to transfer rulemaking and certain other duties, I think the slide is actually wrong. The FTC is to keep the rulemaking, study, and reporting authority. And the CFPB has the Consumer Protection Authority. Sorry, I think I have that wrong on the slide. But in any event, there is yet to come a required negotiated agreement between the CFPB and the FTC, clearly delineating who has the authority to do what and how they're going to coordinate. So maybe in the end my slide will be right, but we'll find out more when that agreement comes out. It's also, I think, interesting to know that they have no authority to enforce the Fair Housing Act. They do have the authority for ECOA, so there's some conflicts there. So HUD and the CFP will have to work that out. I think it's also of note to know who isn't covered in the authority that the CFPB wields. Merchants, so retail merchants for the most part. And then you have entities that are regulated by the SEC or the Commodities Commission, entities regulated by the Farm Credit Administration, and entities regulated by state insurance regulators. Now, the CFPB has the authority to investigate and analyze any person, and that includes individuals, not just companies, that has engaged in conduct which, if proven, would constitute a violation of any provision of federal consumer law. That's a very, very broad umbrella, and it means that you personally, and I personally, and Gary personally, could have personal liability if we were found to have violated any of the federal consumer protection laws.
Especially if it was knowingly and willingly. I think that they have made it a point that those fines and those penalties are much larger, and I think there's still a whole bank of legal folks out there that are going to test this theory in the upcoming years.
Right. I think that there's going to be a lot of litigation. So that kind of brings us to their authority to penalize individuals and companies. We'll start with the easy ones. They can order the rescission or reformation of contracts. So if they feel a contract between a mortgage lender and a broker, for example, violated the law, they could force a change of the terms of the contract. The refunds of money or return of real property, I mean, conceivably they could, change, affect title title real property and transactions is governed by them.
Well, I think we've already seen in a lot of the commentary that a borrower will be able to use as a defense to foreclosure for, in many cases, the entire term of the mortgage, if in fact it's found that the disclosures and there was a violation of consumer protection laws, which, as we'll talk in the next couple of weeks, dives down into the disclosure process.
Right. Some other penalties they can impose is disgorgement. So if they feel that you profited unfairly in some way, they can make you return the money. Damages, public notification. Basically, they can shame you by posting about your bad acts and cease and desist orders. Now, here's the real meat and potatoes of their enforcement authority. They can fine an entity or individual $5,000 per day for any violation. Now, that's any one violation. So, for example, if you violate a truth in lending disclosure, you have an error on your disclosure, that is usually a violation not of just federal law, but it's usually a violation of state law. It could be an unfair and deceptive act in practice. So for that one loan, you have a possibility for at least 3, probably more, violations of law, so $15,000 a day. If they believe you're reckless, and this goes back to what Gary was saying earlier, they can charge $25,000 per day for each reckless violation. So you didn't investigate the law with sufficient thoroughness, and you make a mistake. That's not a mistake. It's because you were reckless. So that's quite a penalty. But the worst one is if you knowingly violate the law. $1 million per day for violation. This is basically the authority to put you out of business.
You know, a couple things regarding that. First of all, we just want to mention that, you know, in the headlines so far, the CFPB has gone after some large banks because that was low-hanging fruit. There's reputational risk, and it's pretty easy to see that there's a lot of violations or potential violations out there. A lot of people say, well, I'm too small, they're not going to go after us. Well, realistically, I think they're setting the stage, and with their guidelines that they put out and the guides that they make truly available, most of us will become susceptible to potential violations and audits from from the regulators. So, you know, I think all of us need to be mindful that we're in a landscape that we're all susceptible to this. So what we've gone over today really is some real basic stuff. We want to just, you know, cover that, you know, brief history lesson, which I think all of us are familiar with because we've lived through it. You know, see the amount of regulations that have been straddled onto the CFPB. As Ann said, you know, they started off just formulating how they're going to do business, and they put procedures in place. So a lot of people say, wow, they've been at this for over a year, and we really haven't seen a lot. True, we haven't, because they only went after a few things, and they've been putting the resources to play. And again, remember, just not only the mortgage business that they have authority over. But just know, as time goes on, they've set the stage, they've given us the guidance, they've given us the regulations, they've given us the tools for us to be able to start understanding what they expect from us. So now, I think as we see this next couple of years unfold, I anticipate that they will be, you know, singling out lenders that have bad acts, and a lot of it has to go through their website where consumers complain. Because remember, this is all under consumer protection laws. So as people file complaints with the CFPB, you can imagine your name, whether you're really small or whether you're really large, your name starts to funnel up towards the list of things.
I would say if you have your complaint in the CFPB system, you need to be very vigilant about protecting your reputation and following up on those complaints, because the more complaints you have, the higher up in terms of how quickly they're going to audit you. I really believe that.
Yeah. So what we've done today, we just wanted to give a foundation overview of what kind of got us here, you know, who the regulators are, some of what their expectations are. So going forward, we want to kind of go through what our anticipated schedule is. And the reason why I put anticipated on there is because there could be some changes if new information filters into the marketplace. But we're starting today with the overview. Next week, we will do a deeper dive into, the nuts and bolts of TILA and RESPA. And again, we're not going to go through the whole history of it, really just how it is today and what changes are going to be taking place. We're going to discuss the following week some higher-priced HPML or HOPA loans and what that means, why you would or would not do them, the triggers that create them, and if they are created, if you can still do them, what additional documentation or procedures have to be in place. We're going to discuss HMDA. A lot of people say, well, HMDA's been out there for a long time. I can tell you from a regulator standpoint, they are looking at our HMDA and your HMDA information in deciding whether there's holes in some of your other procedures and what type of information, fair lending, so on and so forth that's out there, because they are doing our call reports from the SAFE Act, right, mortgage loan call reports, and adding that and HMDA together, and then get a pretty good picture of what goes on in our transactions. We're going to start discussing mortgage loan originator compensation. We're going to take it on a couple levels. We'll discuss it in again, broad stands, and then we're going to come back again and revisit procedural-wise some of the tools that we'll put in place to help our business partners do well, and we'll also talk about some of the things you should put in place to get ready for this. Just remember going forward, as Ann had stated, the regulations also dig down into that individual as well as the company. So loan originators going forward are going to have a lot more at stake than what they've had in the past. We're going to talk about QM, and I think there's been a lot of information out there. There's been a lot of speculation and talk. Basically, QM could have some of the most quantified changes in our industry that we have seen, especially in the area of qualifying a borrower, what documentation will be used, what loans will or will not be eligible, whether we truly have a safe harbor or not, and there's been a lot of talk around that. Again, our vision is to give you guys sound bites, real live stuff. If you want to dig deeper, we're going to give you the links to go into websites and get some source documentation, but we're going to give you street talk of how you should be looking at this. We will take 1 week off, so we're not going to post any new webinars in November, the week of Veterans Day. We do have some internal training that will be required from our internal loan officers, but it will not be part of this webinar series. Then we're going to come back and, again, dig deeper into MLO compensation, the QM, the QRM, that skin in the game piece. We're also going to do a slide overview of servicing, the new escrow requirements and appraisal requirements. Many of you don't realize that the new appraisal requirements that take effect in January are under ECOA, which I think surprised a lot of people. We'll kind of draw those, we'll connect those dots for you a little later on. We're going to go back and look at the combined TIL and GFE. And as Ann announced, we are anticipating that they're going to announce that. The actual date that will be required because of all of the software changes from most vendors will be changed. And we're going to revisit the vendor management piece as well, because part of the CFPB came out and said that all lenders, all brokers, all business partners are, especially if you interrely on one another, we're going to be back looking at how, what kind of risk we allow one another, and in so doing, what kind of safeguards do we have in place. And again, we're going to come back finally right at the very end of the year, because these changes will all take effect. Happy New Year, by the way. Take effect January 1. So the last week of January, we will put how-tos and develop other areas. So with that said, we're putting our contact information out. We'll have that out there every week. If you have questions or you have specific topics you want us to bring up or you want to discuss with us personally, feel free to reach out to Ann. And if she's not available, of course, I would be there as well. But we will, again, as we go along, we are going to take, we will not take question and answers during our 30 minutes because we're going to keep it to that amount. But we will develop an FAQ as we get the questions in, and then we will continue to build. So you guys that are on going through this journey with us over the next several months, we'll give you a list of the questions so you can review them as we go along, because I know we have a lot of brilliant business partners out there that are going to come up with questions, and actually because of that, they'll help us write some of our policies going forward. You know, there's a lot of different other tools that will be available. We will be putting out bulletins, policy and procedure changes that will be in writing as we go along. We'll list things on our website like our FAQs. And again, we're going to be doing our sound bites on a weekly basis all the way from here to the end of the year. So with that being said, I think what we'd like to do is wrap up today's, again, just giving you a basic foundation. So again, my name's Gary Martell, and I'm joined with Ann Savage. And we're going to be going you through a trip through the different compliance over the next several months. Again, our time frame will be 30 minutes every Monday at 1:30. If you're not able to attend one of those, they will be online for you to follow up with later on in the week. I just want to reiterate that we understand how valuable your time is, and we'll make sure our information is concise and to the point, and it will help you get through as we prepare to do business in 2014. With that being said, we thank you for joining us today.
Yes, thank you very much.